The Leader of the Opposition.
Thank you, Mr Deputy President. I lead for the opposition on the Electronic Transaction Legislation Amendment Government Transaction Bill 2017. The opposition does not oppose the bill.
Hear, hear.
Despite its title, it doesn't really have anything to do with the Electronic Transaction Act, but has more similarities with the statute law revision legislation that makes a series of amendments to a broad and wide range of acts and other legislative instruments. This bill has a number of purposes and objects. One is to provide for a trial of digital driver's licences. Despite this involving amendments to the Road Transport Act within the portfolio of the Minister for Roads, Maritime and Freight, carriage of it is with Minister Dominello, I believe, in the other place. The Shadow Minister for Finance in the other place will make some further comments on behalf of the opposition. On this part of the bill, the relevant provisions are in Schedule 5. Schedule 6 of the bill postpones the commencement of portions of the Strata Schemes Management Act, and there will be some more commentary on behalf of the opposition on that part of the bill by our relevant Shadow Minister in the other place, the member for Swansea. But it's worth mentioning that the government, this should be very embarrassing for the government, because when introducing that legislation, it was considered by the government to be a significant reform and was to commence on 1 July 2017. And now this is being delayed by some further months, which really does call into question the competence of the government in rolling out its reform plans, a bit like the Fire and Emergency Services levy issue, which we now understand the government will have to legislate before the budget to unwind, and if they ever get it back on track, to then re-legislate. So that this has echoes of that, and it's becoming a bit of a habit with your government, which must be causing the community to question your basic competence. Other aspects of the bill include the facilitate of service of documents by email to allow for the use of approved forms instead of using statutory declarations, and to provide for the online publication of public notices, announcements and advertisements. There's also a proposal to make minor amendments. In particular, Schedule 4 contains amendments to a range of different acts. Schedule 1 amends 40 acts or regulations and allows notices and other documents to be served by sending the notice or other documents concerned to an email address specified by the recipient or by other means as may be prescribed. Various ways of service are set out, and the provisions include many different methods. So quite exhaustive methods. I'd ask the Minister in reply, or the Parliamentary Secretary, to indicate what the actual purpose of the regulation-making power is. Schedule 3 provides amendments allowing for the online publication of government notices, not just restricting it to publications in the print media in relation to provisions in the Charitable Fundraising Act, the Land Acquisition Just Terms Compensation Act, Storage Liens Act and Uncollected Goods Act. These provisions provide for publication on a website that, in the opinion of the authority or agency concerned, is appropriate to cause the notice to come to the attention of the persons in the district concerned, which seems to potentially expand the discretion of the agency concerned. For example, this would seem to include notification of compulsory land acquisitions. And so the question is the provision designed to hide rather than to disclose such intentions? So I'd ask the government to clarify that.
So cynical for one so young.
I acknowledge that interjection caused by the actions of your government over the last, 6 years.
Let's just organise, I think.
Now, this seems to potentially expand the discretion of the agency concerned. The provisions being replaced refer to papers circulating in an area concerned, which to us seems to be a more objective and clearer test than the one which it replaces, relying as it does on the opinion of the agency. Schedule 2 provides for the use of approved forms to replace statutory declarations in relation to the Association and Corporations Act, Conveyances Licensing Act, Cooperative Housing and Star Bowkett Societies Act, Duties Act, Fisheries Management, Aquaculture Regulation, the Impounding Act, and in fact an exhausting array of other enactments. Criminal penalties will apply to false claims in approved forms as they do to statutory declarations. The practical purpose of the amendment is to allow forms to be completed online, but the sidelining of justices of the peace achieved by the legislation does seem to be part of a wider trend, and the government's disregard of requests made by the New South Wales justices association, especially relating to training and JP's portals, is consistent with the sidelining of the role of JPs, and the recent attitude by the Department of Justice about proof of life forms and JPs is unexplained, to say the least, as well as profoundly inconvenient for many constituents of many lower house members. Sidelining their role, as this legislation does, almost as an incidental consequence, is unfortunate, unless, of course, that was actually the intention of the government, and if it was, you really should have drawn someone's attention to it. And with those pointed remarks,
Yes.
we will not be opposing the legislation.
Here.